joining us today. So for the students watching here, of course, this is our very own esteemed Professor Mark Pearson, our very own media law specialist. And we're going to go over some tips today for students who maybe feel a bit rusty on their media law and are doing their third year subjects and really just want to go over perhaps things they can brush up on, both in their media law textbook and just to know generally in their life as journalists. So thanks for joining us.
That's a pleasure.
Professor Pearson.
Pleasure, Nance. Yeah.
So, Mark, is it possible to say area? Is it that simple that you can go to a court story and know what the danger areas are going to be when you're doing a court report?
Well, if anyone was going to be covering court or any story to do with the police and crime, I'd thoroughly recommend brushing up on their media law, particularly the various time zones and the red light issues that are danger zones for reporters when you're covering court or crime stories, because so many areas of the law kick in. In fact, most journalists who start covering court actually go to court for a week or so with a mentor before they actually start reporting.
Really something that it's just something you have to be constantly brushing up on and even going back over the textbook. It's certainly not a textbook that you're giving away by the sound of it.
No, well, obviously the main areas that kick in with media law and court reporting are the areas of both defamation and contempt of court, and along with a host of publishing restrictions that vary from state to state, but the general principles apply throughout all of the Australian states and territories. And they're very special restrictions on things like not identifying sexual assault victims. In Queensland and South Australia, not even identifying the accused in sexual assault cases until they have actually gone through the whole committal process. Now, if you don't know what the committal process is, that's another reason why you need to be revisiting your media law textbook and your notes about the process, the criminal process, and the various stages of a trial.
So, Mark, one of the students, I've had a few questions from students that they wanted me to ask you, and particularly they just asked, are there specific topic areas that are particularly fraught that they should steer clear of to a degree? Is that possible to define?
Well, in a court case, the big things where you would normally not be allowed to identify people and you'd need to be very restricted in your coverage would be those matters to do with serious sexual cases, matters involving juveniles, child witnesses, and anything said in court or documents tabled in court that the jury is unaware of or not allowed to know about. And that introduces the whole area of contempt of court, sub judice contempt, where there are very severe restrictions on not putting anything in your court report that's not fair and accurate, a fair and accurate account of what has happened in open court in the presence of the jury.
You to say as well, Mark, I have had a few students saying, yes, they know that it means a court trial is ongoing, or as it is in Latin, I believe, it's before the court. But what does that actually mean for us journalists who are reporting?
Well, for journalists, it means you need to refer to those time zones as to the restrictions that apply, because what you have with a typical major crime that the public is interested in is typically you would first have the crime being committed, but perhaps the police still searching for a suspect. And you can pretty much say what you like during that period before they've actually arrested or charged anybody, but remember it's subject to defamation law. So at that early stage, if you were to defame someone by perhaps saying the police were considering them as a suspect or something like that, then you would have to very carefully navigate defamation laws at that point. The next stage comes when someone's been arrested or charged, and that's the moment at which all of those sub judice restrictions start. So once they've been arrested or charged, but before they actually appear in court, if you identify them by name or narrowly enough for people to know who they are, you're still at risk of defamation, because the charges could actually be dropped at that point, and you're left having associated them with the crime, and the police don't even have enough evidence to pursue them. But it's also the time at which you have to be wary of not prejudicing the trial in some way. So you can't reproduce their visual identification if their identity might be an issue in the trial. And for big, high-profile crimes, that's normally the case. It relies on witnesses being able to identify them. You can't insinuate their guilt or even their innocence in any way in that preliminary period. You can't reproduce material like their a confession or their character, evidence about their bad character or their criminal record and those sorts of things. So in those early stages, before there's an actual court hearing, you have to be very restricted, right back to pretty much an anonymised account of the bare facts of what any witness would bear testimony to. Basically, a body's been found by the river, found by a passing jogger at 6 o'clock this morning. It's the body of a female. The police have identified her as, if there has been identification, and that kind of information, but nothing to do with what the suspect looked like or whatever once they've been arrested or charged. And then we start working through the preliminary proceedings, and normally, unless you're in a state with a particular restriction or unless there's been a suppression order issued, you can report those bail hearings and the committal proceedings. In Tasmania, it's an offence to even report a bail hearing, for example. So there are various state-based restrictions. But during those proceedings, unless the court issues a suppression order, you are allowed to write a fair and accurate report of the day's proceedings. And it can be in that early stage that their criminal record is mentioned in open court, perhaps during a bail hearing, and that is all reportable. The mistake journalists make, though, is that once a jury has been impanelled and once that early stage has passed, some journalists go back and repeat some of the information from the earlier proceedings, which is no longer allowed. Now, unless the courts issue what's called a takedown order, you're not required to take down the earlier coverage from your site, but you can no longer link to it.
Okay.
Like build it into your stories or have it on your site there next to the story. Often news organisations will have a thing called related coverage, where you can't have that there at that point. So technically, those restrictions on what you can say last right through till the end of the trial. In fact, technically until the end of the trial period, the appeal period. But most journalists are pretty safe once the trial has finished to start publishing that other material.